All right, this panel is the impact of unauthorized scraping on users. Our moderator is Tejas Narechania. He's the UC R&N course and assistant professor of law at UC Berkeley School of Law. Hannah Shimko, who's the communications and policy director at the Online Dating Association. Calli Schroeder, who's a senior counsel and global privacy counsel at the Electronic Privacy Information Center. Brandie, Nonnecke, who's the founding director for the CITRIS Policy Lab and associate professor of technology policy research at the Goldman School of Public Policy at UC Berkeley, as well as Sarah White, who is VP Legal Litigation and Competition and Enforcement at LinkedIn. Thank you all for being here.
Okay, I guess I'll just kick us off. Let me start by saying thanks to the organizers and to everyone for being in the audience, both virtually and in person. And thanks for tolerating our presence virtually. I know you're all in a conference room looking at a screen, which is not always the best, but I think we're going to have a great conversation. I'm really thrilled to be moderating this conversation with 4 amazing panelists. So Sarah, maybe I'll start by asking you a question, which is just, LinkedIn has obviously been involved in some high-profile scraping things, as the last panel talked about. Maybe you just give us an overview of sort of what's important for people to understand about scraping, and in particular, unauthorized scraping.
Sure. So I've been at LinkedIn for almost a decade now, and I've been actively involved in working to stop abusive, unauthorized scraping pretty much that entire time. One thing I just want to note is that the opinions I express here are my own, and I'm not speaking on behalf of LinkedIn or its parent company. I could spend our entire 45 minutes answering just your question, but I'll try to do it in just a few. And I think there are 3 key things that I would emphasize. And the first, was addressed in the first panel a little bit. It's just that it's complicated. It can be hard for people to reach a shared understanding of what scraping means and when it is authorized. And for me, boiling it way down, scraping is copying information on a website using automated processes, usually at scale. And it's unauthorized when the website owner has made clear that they don't want you to copy it, whether that's through terms of service or code-based instructions to bots or technical measures designed to detect and throttle or prevent automated visits to the website, as opposed to human traffic. One really important thing to understand that I think often gets lost in these news cycles that come up, periodically, is that scraping is not a data breach. It does not mean that an attacker has been able to get inside a company's secure systems or subvert firewalls or access, sensitive protected network information. And then relatedly, a website owner has not done something wrong or failed to do something they should have just because someone came onto their website and scraped information from it. It's quite literally impossible to stop all scraping through technical measures. And the reason for that is that once a web page is rendered to a user, and whether that user is real or a bot, it's just not possible to control technically what that user does with the information. So we can impose limits, and we can detect patterns suggesting bot as opposed to human activity, so that we can then block suspicious IP addresses. But even then, the effectiveness of those technical measures has to be weighed against their potential negative impacts on site function and responsiveness, which also is obviously very important to users of any website. And then the other key thing I would say that's related, another key important thing to understand is that even though it's not a data breach, unauthorized scraping is often a violation of rights. And, I think that, often got lost in, public discussion of the HiQ case. These false, headlines saying, oh, court rule scraping is legal. Scraping, unauthorized scraping can violate the rights of the website owner who didn't authorize it. The website owner who may have taken considerable steps to prevent scraping contractually and technically, and who, likely invested a great deal of time and money in their business and their website and the people who use it. And when that scraped data in particular is about people, it can violate their expectations about who can handle their data and what can be done with it. You know, it can harm them, it can annoy them, it can open them up to unwanted intrusions. And in the case of LinkedIn in particular, you know, our focus is enabling members to represent themselves and create their professional profile of record, and giving them the power to represent themselves in the way they feel is most appropriate at any given time. So they expect to be able to control how they represent themselves and how they engage and navigate important professional relationships. And so when people scrape profile data from LinkedIn and use it for other purposes and other locations, they're taking away that control from our members. So just to use HiQ as an example, because it's a convenient one, you know, they used data scraped from LinkedIn to tell people's employers who was a flight risk based on things like changes they made to their LinkedIn profile. And that really thwarted people's expectations that small changes to their profile, while public, you know, would not be noticed. And it just introduced the possibility that employers could take negative actions based on that information. You know, people sometimes post inaccurate things by mistake, or they want to fix something or emphasize different aspects of their experiences. And the inability to delete scraped data about yourself really prevents people from moving beyond their past selves. And then I guess one other related note, you know, the unauthorized scraping, again, although it's not a data breach, it's not a security issue by itself, it does have the potential to increase risk of things like fraud or identity theft. And that's particularly true when data scrapers are willing to sell the personal information that they're collecting or combine it with other data that can be used, again, for other purposes that the people who gave their data to the website they have the relationship with, you know, weren't anticipating.
Thanks for that overview. There's a lot in there to react to, sort of, you know, the distinction between unauthorized scraping versus abusive unauthorized scraping, sort of what modes make, or what's enough to make adequate notice, clear and adequate notice that scraping is not allowed under circumstances, or when it is or isn't. Some of what you said actually makes me think back to some of the old copyright debates around the DMCA. This sort of, you know, this sort of problem of, once the website is rendered, it's out there. And that sort of reminds me of the analog gap, and that, you know, you can try to put as many DRM restrictions as you want on an audio file, but once you play it, the sound waves are generated, and there's only so much you can do to control that. Okay, there's a lot to react to, but maybe what I'll do is invite Hannah and then Calli, if you want to come in and maybe say a little bit about, just build on that. What are some of the risks? What are some of the impacts to the ecosystem of users, industry, government, academy, for scraping?
Yeah, I mean, I think that Sarah's introduced this really well in representing online dating services. You know, we have a lot of similar issues that LinkedIn has. So if you think about online dating, we put a lot of personal information about ourselves into that online dating ecosystem. And to emphasize again, this isn't IP addresses and email addresses and that PII that is held behind our safe spaces, safe walls, but the information you put into your dating profile in order to be matched, in order to find that potential love interest, is quite personal still. And I think with online dating services, it's an interesting situation because it is a somewhat closed landscape in that many dating services are kind of semi-private ecosystems in which you have to join that dating service in order to see profiles. However, if you join that ecosystem, you can see many profiles. So there's that element of, to users, you know, how private is that data? But it's of absolute importance to dating services, of course, to create that relationship of trust between themselves and their users, to share this like very personal part of their life. So the biggest impact that we, you know, of course, see is that loss of trust between our users, which is, you know, ourselves and our users, which is so essential to positive dating experiences, and of course to dating companies that are trying to deliver that. I think that we have a range of really negative impacts, and they may not be what you initially think about. You know, I think like LinkedIn for their professional lives, these are their romantic lives, which are something that they feel should be kept to themselves. But we've had instances where the entire websites have been copied, scraped and copied and put up elsewhere as completely fake dating websites. So huge loss of trust there for an individual who felt they were joining one specific dating service, gets put up elsewhere. Their own data is out there, their images. Dating services, of course, are highly based on images, and you can't hide your face in a dating profile. So that is then out there on another site you don't control. Huge impact for the company itself, because it's seen as though, you know, my members shared with me they got lots of messages saying I didn't agree to have my profile on this other website. It turned out it's a fake website. There's also the possibility we connect dating profiles with social media profiles, and if that data is scraped, it can be used to solicit on social media profiles. So you might look at a demographic on a dating service and use that to then solicit for other more illegal offerings, or to try and scam by using some of the information from that dating service to get into people's direct messages on a social media platform or other areas. So huge risk to the user from having their data scraped off a dating service with the information that is somewhat public. We have concerns around blackmail or other nefarious purposes. So if the data is scraped from what dating website that is for a niche interest, you might think about that, or in a country where that community of data is a protected characteristic, but maybe that's illegal in that country. Huge ability for blackmail and used by bad actors. And we also need to think about victims of stalking or domestic abuse who have looked for a safe space to date again, and then if that information, that their personal data is taken from that dating website, could be used for causing harm. We also have the kind of broader web scraping of blogs and marketing materials. So a lot of dating services use marketing materials from their users. So success stories, you've probably all seen a dating success story, and those get scraped and copied onto other blogs, and the daters haven't given their permission for their images or their story to be used elsewhere. So they're all just examples of a breach of trust, in that dating users feel that their information is within one specific ecosystem of kind of exchange of data between daters. They know it's not completely private, but on that broader scale, they don't expect it to be out there. That's kind of an overview of where we are. I think we haven't come up with solutions yet. So I appreciate the first panel, made me think a lot. So I look forward to discussing later.
Calli?
Sure. To kind of jump in, I think when I look at potential harms to individuals, specifically when it comes to data scraping, I think there's two tiers of levels where harms occur. One is at the initial scraping. So when the data is taken, it removes the possibility of control or edits over that data. If I put up information on, say, LinkedIn or a dating site, I may want to change it in the future. I may decide that I overshared at first, and I don't want to have that out there anymore. I may decide that the way I typed something isn't totally accurate, and I want to adjust that a little bit. Once that information is scraped, you don't have the power to adjust it anymore, and so that's completely gone. And if I want to remove it, that's gone as well. Another factor is the intent behind sharing. You know, if I'm sharing information within, say, a dating site, I intend for that information to only be visible to other members of that site, and only for the purposes of, you know, trying to form a relationship. I don't intend for it to be spread to multiple other companies, put on multiple other sites, shared with multiple other people, or put into, say, a file on me that draws from multiple other sources and then gets much more granular information about me. And that leads to the second stage of harms, which is after the initial scraping. It's very easy for this information to be sold to data brokers, to be combined with a lot of other data sets. And then once that happens, there are inferences that can be drawn from large patterns of information. Algorithmic or AI-driven inference generation is very specific. Even if it's not always accurate, it still gets used very frequently. And that can be used for scoring or for results when you're going to do other things in your life, when you're applying for jobs, when you're applying for housing. So the scraping ends up causing some serious damage there when it leads to inferences or leads to profiles that can cause damage through bias or through improper use, improper conclusions that they've drawn. There's a lot of issues there. And then beyond the harm to individuals, which I think we always focus on because that's kind of my focus in general, there is real harm to the companies that are hosting this information and who have had their terms violated or have had their purposes violated. As mentioned before, real issues when it comes to trust of those websites, even if they've taken technical measures or put in place policy measures trying to prevent this exact scenario. And there's a problem down the line. If trust continues to erode, people won't use these sites. People won't share their information because they don't feel safe doing so. And in some ways that can kind of make this whole system defunct. And in another way, it can also be a real problem for people who need to use certain types of data scraping for their work. So journalists and researchers frequently will use data scraping in their processes, but those tend to have more barriers around them. They're for a specific purpose, they're for a public good, there are protections built in for how that information is used, so it tends to be a little more ethical. And that process is going to go away, again, entirely if data scraping keeps being misused by individuals and by companies for unapproved or unethical practices.
That's really interesting. And I think that calls to mind one of the things that I alluded to earlier, which is the difference between abusive unauthorized scraping and unauthorized scraping. So scraping that's maybe for the purposes of security research or news and journalism. And so Brandie, I wonder if you might talk a little bit, not only about the risks, which we've heard quite a bit about, the risks and problems that attend to data scraping, but maybe this possible benefits, or what are some of the things that we have to balance concerns about data misuse against, like these sorts of research projects?
Yeah, thank you so much, Tejas. And the discussion so far, really interesting to me. I think to just start, of course, platforms hold vast troves of data that can be incredibly impactful at documenting things that are of public interest. For example, documenting the spread of disinformation, documenting public health concerns and appropriate interventions. But I am sympathetic to the companies and what platforms are facing, whether it's ensuring compliance with data protection laws or protection of proprietary data and models. Probably many of you in the room and online saw that Meta was fined about $275 million by the Irish Data Protection Commission for violating Articles 25(1) and 2, which is essentially the portion of GDPR that says that anything you build should be data protection by design and by default. Now, as a researcher who has used the APIs and also explored use of scraping, this causes me a little bit of concern because the companies, I believe, will put in place more of these technical barriers for third parties to be able to scrape. And I completely understand why they're doing it. When you're implementing those technical barriers, however, it's not like the company can know whether or not that third party that's scraping is doing it for altruistic purposes or for malicious purposes. That'll come out later. In the last panel, I heard them discussing that maybe we should have some type of law at the federal level that defines scraping, sort of sets guardrails for what's appropriate or inappropriate. Also on that panel, and I'm an academic, we noted that not all research is good for society. It can be incredibly harmful, and that we tend to rely on these institutional review boards. And I would say of myself going through that process of having projects reviewed by institutional review boards, typically they've taken the stance that if any data is publicly available on a website, it's free reign. So I do think that there needs to be new training for institutional review boards to be able to better scope out what types of practices researchers should be engaging in. And then quickly, before I hand it off for the next question, I wanted to raise up two pieces of legislation. The European Union has been just moving forward at a lightning pace, I think, definitely in comparison to the United States, on pushing forward some more laws that will actually try to address some of this problem. So the European Union passed the Digital Services Act, which will create a mechanism for what they're calling vetted researchers to be able to gain access to platform data. And this is in collaboration with the platforms. The platforms will be able to push back and say, we don't want to share that data because there are personally identifiable information concerns. We don't feel it's compliant with GDPR, or it's proprietary data. We don't want to share it. But, they're creating this mechanism. It's a great first step, but also as a researcher myself, the timeline for this process of becoming a vetted researcher, of coming up with your research question, your hypothesis, which is supposed to help identify systemic risks, identifying the data. This is a very, very, very long process and a high barrier to entry. Only a few researchers, I think, will be able to actually gain access to this data. And then quickly in the US, we have a similar bill that was proposed at the federal level and also in the California legislature called PATA, the Platform Accountability and Transparency Act, which would perform a very similar function in the US, with the NSF and the Federal Trade Commission serving as sort of vetters of the research and a data broker between researchers and the platforms. I also want to note quickly that in PATA, there is a protection for scraping. There's essentially like a shield for researchers who are using scraping to gain access to data, and flagging that, because in our discussion here, even though it's allowed, we need to be conscientious of what data researchers are pulling in and what they're doing with that data.
So if we have time, I would love to hear from everybody on sort of not how PATA is written, but how you think it ought to be written. So how would you design a sort of legislative approach that strikes the right balance? But before we get to that, actually, Brandie, I want to go back to something that you said and then ask you to respond, and then maybe bring everybody else in too, which is, so one thing that you said that you found troubling was the way IRBs, institutional review boards, think about public data. And they say, like, look, if the data's on the website, it's public and you can access it. And Sarah and Hannah and Calli, you all sort of have been some sort of discomfort with that, which is, well, look, like, people should be able to go back and revisit their, like, edit their tweets if we ever get that edit button, or like fix their profiles, or change their pictures, and sort of have control over their online profile, their online destiny over time. And so I guess the question I would ask is, how do we know then when online content, or when like something you post through a platform is sufficiently public such that it's okay to scrape, versus when it's not, and who should say?
I'm shaking my head now. That's such a tough question, Tejas. I think, well, we have a proposed data protection law at the federal level, and California has the California Consumer Privacy Act and the California Privacy Rights Act. I will say that in the CCPA, there is a provision that you do not have to comply with your user requesting a data deletion if that data is necessary for research that serves the public interest. And I can feel like the collective cringe of everybody hearing this, because what is the public interest and what does this mean? And is this going to be scoped so broadly that any data will be maintained because it could potentially be used for public interest research? Yeah, so right now, essentially, the companies and the researchers are deciding what data should be made available.
So Sarah, taking as given that your comments do not reflect the views of LinkedIn or the parent company, I'm interested in your thoughts, because I suspect you've spent a lot of time thinking about this question, which is, how do you know, like when is it okay to scrape, if ever?
I have thought about it a lot. I mean, look, this is why this issue is complicated and hard. But at the end of the day, and again, I'm speaking from my own personal perspective, but also just from the perspective of thinking about it when it relates to personal data as opposed to facts about whatever. I think that the user, the person whose data it is about, should have a say in how data is used and whether it can be scraped. Now, I don't know, maybe that means we need a setting, but I think, if we have we have a relationship, LinkedIn does, with our members, where we promise them we will only use their data that they give us in certain ways. And we lay all that out. We are obligated to them in that way. We are accountable. And ultimately, when people come and scrape without permission, and use it for purposes other than that, like that relationship of accountability and trust doesn't exist with that third party. So for me, I just keep coming back to that. When it relates to personal data, I think it's important that the person gets to choose whether or not random company can access their data or not.
I mean, so that's interesting. It sounds like user control over personal data is important. But one thing that I think you said maybe a little bit quickly, and maybe I'll get into trouble, is that there's a distinction between personal data and facts. And I wonder how you would draw that distinction.
I just meant, that was probably just inartful phrasing. I meant data about people as opposed to data about things. Like, are we talking about flight schedules or, directions to a park, as opposed to like where a person works or what they look like or other personal information about them.
Got it. Okay. Hannah and Calli, same question, but maybe we'll go in the opposite order this time. Calli first and then Hannah.
With the caveat that I am very much a tech lawyer and not technical, like I don't have tech knowledge. I think it would be interesting to see if there were some way to essentially lock down sites to the point where scraping couldn't really happen unless users got a prompt for, unless people that wanted to scrape had to essentially submit a request to scrape and then be approved. And in that way, you could screen a lot better. So you could make sure the intent behind scraping is something that is permissible or ethical. So in those cases, you could do something where journalists or researchers maybe are permitted access in ways that other companies aren't. I don't know if it's technologically possible to do that, but you mentioned this is idealistic, so I'm throwing that in there. In general, if we were looking at a law that had to do with scraping, I would err on the side of altogether banning rather than allowing if we can't find a way to make that nuance happen. If we can, I think that there are ways where we could propose that APIs be set up on sites that allow for not scraping, but basically an alternative that accomplishes some of the same goals, but in a much more controlled way. We could possibly go by intent. The GDPR in some ways goes by what the purpose of the processing is, what the purpose of the collection is. So we could try to make a law that says scraping is permissible for these processing purposes. That still wouldn't necessarily technologically stop bad actors from scraping, but it would mean that if they did and they couldn't demonstrate that there was a valid purpose behind it, if they got caught, you could go after them for it. I don't know if there's a perfect solution for data scraping, but I think those are approaches that could maybe start to get at the heart of the issue, which seems to be just people misusing this process.
Can I quickly jump in on this? Calli, that's an excellent point. But I disagree. I don't think that we should totally ban scraping because of the great benefits, not only for research, but also for like building up new companies, and companies themselves rely on scraping, like their own other pages of things that they've developed. So it's just too valuable of a mechanism. And then the technical mechanisms, like, can you actually block it? I think, unfortunately, it would probably make any web page completely unusable because of, like, there'd be like a CAPTCHA every time you scroll down the screen long enough, and you'd have to put that in. But yeah, I'll leave it there. I have a couple other points, but Sarah, I see you unmuted, so I'll let you go.
Oh, no, I agree with you. The technical feasibility is what I was referring to, at the start, that there's just no technical way to prevent it in every instance that wouldn't make the site, wouldn't make the site unfriendly to use.
I want to make sure we get to Hannah, but then I want to build on exactly that question.
I'll be brief. I think I was just going to talk about, in the context of what is on the internet forever, dating profiles are absolutely not meant to be on the internet forever. That's not the intention when someone joins a dating service. It is for that period in which they are looking for a relationship, and users do usually delete their profiles when they find that relationship. So when any of that data is scraped and is elsewhere, that is in direct contradiction to the intention behind dating services and to the terms and conditions of dating services. We've mentioned GDPR, there's the right to be forgotten in GDPR countries as well. So there's an assumption with people in those jurisdictions that they can completely be forgotten from their dating profiles. However, we have the interesting situation in dating and that profiles may be deleted. However, a certain amount of data is kept for at least 2 years because of the potential, and it'll be the same for any social platform, of harm having been committed on those platforms. That data and that information has to be kept for a certain amount of time in case there is a situation in which the police need access to that data if a case comes forward. So we are already kind of grappling with that. Is this data staying for a certain period of time and then it's kept in a different way for another period of time? And if there is concern about a profile or an interaction by the dating service, it might be kept for an even longer period of time in an encrypted manner, but in a way that it could be called upon if it is required in terms of dealing with harm. So we've been thinking about this in other areas, and I think it would be useful to use that in terms of this conversation.
Thanks. That's interesting. I'm trying to decide what direction to go in. I'm gonna go back to the question of sort of implementing technical protections and the sort of balance and trade-off between the user experience and protecting data. And I guess the underlying question is, if data is public or could be public, right, whether it ought to be public or not, one question we might ask is how we should protect it. And so you could imagine a couple of things, right? You could imagine a more robust set of technical measures that, as you've suggested, have effects on the user experience, or you could imagine a more robust legal regime. And so the general question is, how should we try to protect the data, against unauthorized or problematic abusive scraping? And the more specific question is, if you could only choose one, technical measures or legal measures, which approach do you think is more effective, however you want to define the word effective? And Calli, I want to start with you because I think you wanted to say something on this, and then we'll go to Sarah.
No, I was giggling a little bit because when it comes to the battle between technology and law, I think it kind of comes down to what you're most familiar with. I would love for technology to be the solution. I don't know it well enough to know if that's even possible. So I would probably err on the side of using a law for it because that's what I know, but I don't necessarily think that that's always the best. I don't necessarily know that they always get enforced the way they're supposed to. And we've run into the problem multiple times where the law is just not agile enough to adapt for how fast technology changes. So that's what I know, that's what I would go with. But if technology has a better or quicker or more adaptable solution, that would be great.
Sarah?
Should I jump in? Yeah.
Yeah.
So I'm also a lawyer, but I have a different viewpoint. I don't think that one should have to choose. I think that fighting unauthorized scraping requires both legal and technical steps. But if I had to pick one, I would pick technical steps every time because it's technical measures that are scalable. LinkedIn, like speaking from the legal arm of, protection, and in my experience with that, you can file lawsuits. That's something that LinkedIn has done a number of times over the years with success. But there are many, many, many more scrapers than there are time and resources to file lawsuits. We've also sent letters, explaining to people, you can't do this. This is why. That can be highly effective. But at the end of the day, like, you need technical measures to stop something at scale. Whether that's the detection technical measures that I referenced earlier. Repeat abusers might need to be restricted from using the platform entirely. It's not scalable to sue every violator unless I get a much bigger team.
Hannah or Brandie?
I have something. I actually think that it's both technical and law. And, Lawrence Lessig very famous lawyer, said once, code is law. To me, the technical implementation is informed by the law. The law will shape those technical measures, and technical measures as they are developed over time will help to shape the legal or regulatory requirements that are made available. So I think it's actually both in collaboration directly with each other. And one other thing I want to bring up is that, okay, let's say a third party does scrape a lot of data, and we see this right now with these very large models, multi-purpose, general purpose AI models, scraping large amounts of public data. And the Federal Trade Commission, as one remedy, is starting to say, you know, maybe there should be this algorithmic disgorgement. So if you are making, you know, you're using this data, this ill-gotten data, you should have to purge it out if it was found to be collected in a way that did not adhere with any legal requirements. However, though, implementing that in practice is much more difficult. As companies right now are pretty successfully able to push back and say that it's nearly impossible for them to remove that data, except we've seen some examples like with Clearview AI in the Illinois biometric law, where they had to remove any individual's data from Illinois. But I would say that's definitely a space to look at, that's at that direct intersection of a regulatory requirement and a technical process.
And yeah, just to say very briefly on that topic, I think that having the legal, and I'm definitely not a lawyer, having the legal framework would be useful, but only if there's a regulatory regime that comes along with it, because the majority of companies that are medium to small size would not even be able to access any sort of litigation. So unless there's a third party regulator trying to create processes in which you can deal with this happening. We're dealing with this in the UK at the moment with the online safety bill. You know, the legal element only means so much if there's not a regulator. So if there is a regulator, then the technological solutions become available for all size companies, not just those who can develop their own technology. So it kind of creates its own ecosystem around delivering the outcomes of that legislation.
But so on that, sort of on exactly the sort of, you know, when a regulator can take action or when a lawsuit might be filed, or the sorts of technical measures that you might want to implement. So I should note we're actually getting into our last 5 to 10 minutes here. So if you're in the audience and you have a question, please put it into the Q&A. There are a few questions that are already in there. And so actually the next question I have is one of these, which is, the question asks exactly sort of, are there ways to detect when scraping is happening? And is that useful to know? And so there are ways to detect when scraping is happening. And I guess, you know, the question I would ask you is sort of, maybe talk a little bit about how you detect scraping. I don't want you to give anything away that you can't give away, but sort of how you detect it. And what sorts of information would regulators or enforcers need to have if we were to imagine a sort of a public legal regime around unauthorized access to web data? Hannah, do you want to start?
So a great question. I'm not going to be able, as I'm not a technologist, I represent my broader members. I'm not going to be very good at answering how do we detect if web scraping is happening. I'm still learning about web scraping as well. So I'll just say, I know it is possible in some circumstances and not in some circumstances. And Sarah, you can probably answer this question much better than I. But in terms of a regulatory regime, I think it's having a mechanism in which small and medium-sized businesses are able to, in the first instance, report when this is happening, and having some sort of centralized database space in which it can be recorded and, I guess, acknowledged that this is happening in all these spaces and this is how it's happening. We've dealt with similar in terms of fraud. I apologize, I keep bringing in examples from other areas that are issues, but we've moved further with fraud in that there's a conversation going on between all the parties who are being impacted by this, and we're not at that place, I wouldn't say, from our perspective with web scraping yet. So that would be the first instance the regulator would be able to create a place where this information is shared, this data is collected, and then those with more technical knowledge in terms of regulation could say this is how we could move forward. That's a poor answer, but my area of expertise only goes that far. So I'll let Sarah give more.
Sure. Well, with the caveat that I too am not an engineer, I would say, broadly, companies that are concerned with, scraping at scale on their platforms would typically put in place several layers of technical barriers to try to thwart automated activity, and that would include things like rate limiting, machine learning models that detect patterns in visits to the website that are abnormal and don't seem human. Scrapers, there was reference to this, I think, in the first panel. Scrapers are get more and more sophisticated, more and more advanced at faking being a real person, through a variety of mechanisms. And so basically just having a machine learning model that continues to get better as scrapers get better to detect and, again, block or thwart some of that activity.
Brandie?
I agree with what Sarah's saying. Yeah, there's these, machine learning models that can identify this and, raise a flag for the companies to intervene. I think one thing that we haven't really touched on that we should is that the companies, they do see these third-party scrapers, and I do commend them that sometimes they will reach out to those researchers. So if they know it's a researcher scraping this data and say, hey, we noticed that, you've been scraping data, and actually start to form a partnership or a relationship with them. And I think that's incredibly important. And I think there's often this perception of an adversarial relationship between researchers and the platforms, but I would like to see that dissipate a little bit, because the companies and the platforms, if they work with researchers, that research could be used to improve their products and services. I know that there's this fear that the research insights might be used and shared with, state legislatures or the federal government, and then there might be laws based off of that research. But imagine those companies being beholden to a law drafted on research that they had no play in and that they didn't inform. And what if it's completely incorrect? Now they're beholden to some, overly burdensome law that they have to implement. So instead, I think it's really important that we continue to foster collaboration between the stakeholders to be able to share data in ways that supports all of the great benefits that we can glean from platform data.
And Calli.
I don't know that I have a ton to add to this. I think everyone else is more knowledgeable about how exactly you can detect scraping and that coming up. I will say that there have been some really interesting court cases lately addressing what happens when scraping has happened kind of at large and en masse and formed its own databases. Clearview AI is the example that always comes to mind there. And I think it's interesting that there now not only is technology that can apparently determine when a site is actively being scraped, but also there are a whole lot of online internet sleuths that are looking after their own privacy or other people's privacy and will send up flags when they see that there's information that clearly has been copied and taken from other sources. So that's kind of an additional component of this situation in tracking scraping practices.
I'd like to add something quickly to that. Calli, I'm really happy that you brought up Clearview AI, because they've scraped over 20 billion facial images. And of course, this violates GDPR, and you see that they are getting fined. So France and Greece have already fined them, but essentially it appears that Clearview AI is just incorporating these fines as part of the cost of doing business, right? They're so big in the space and they have so much money that them paying a $20 million fine seems like it's nothing. So I think that's something we have to think about when we're talking about remedies. If we're going to issue fines, I think we'd better make sure that the fines are steep enough to really be a real slap on the wrist of these companies. Otherwise, they're just going to set aside that money to pay the fine so they can keep operating.
Okay, I think we are technically out of time because the panel's supposed to go till 3:50, but I guess I want to give each of you a last word, and maybe I'll ask you to answer a specific question, which is, if there's only one thing that you wanted everybody to understand about data scraping, and I mean everybody, not just lawyers in the room, but users, what's the one thing you would the one message you would want to convey to everyone? And I guess we'll go in the order we started in. So Sarah, Hannah, Calli, and then Brandie.
If I'm allowed to only say one thing, I would probably still go with it's not a data breach.
Okay, it's not a data breach. Hannah.
Similar to what I was thinking, but that it's an area that needs collaboration. We need to talk about it, share, and find solutions together.
Not a data breach in need of multi-stakeholder solutions. Calli.
I think it's a really good prompt for talking about what public data can be used for and what the intent is behind it. I don't have a super succinct summary of that, but I think it's an important conversation that we've been having in the privacy community, and it's only going to become a bigger topic of conversation.
Okay, so not a data breach, but rather a forum for a multi-stakeholder conversation to talk about norms around what data is public and private. Brandie, I'm trying to put it together.
I will say I agree with everything everyone before me has said, but I would also just warn that any technical or legal or governance mechanism put in place that we think really carefully about, okay, if we're trying to mitigate a harmful data scraping, are we also inadvertently harming beneficial data scraping that really benefits society, and really balancing the benefits and the risks?
Not a data breach. Rather, we should think about the different stakeholders who have different equities, both pro and con in data scraping, so that we can come up with norms about what data is public and private. Thank you all so much for a really fun conversation. I really appreciate it. And thanks again to the audience. This was a lot of fun.